Do the little ones. Give me that other one. Mhm.
So you want me to start using my hand? I thought.
No, just leave it right there.
I know you just for your numbers.
Oh, yes, everyone, please sit where your number is. Sir, what is your number?
Well.
All right, you need to sit at number 12.
Well.
Is he available?
Which court are you?
All right, excuse me, which court, excuse me, sir, which court are you supposed to be in?
I'm not sure. It's maybe last Monday. Somebody just.
27 foot, you're in the wrong foot.
On this floor, sorry. On this floor. Down to the left.
What did I tell you all about jurors coming to different courts?
Be more helpful.
And I didn't believe it.
All right, everyone, please be seated. All right, State, you may proceed.
Thank you, Your Honor. Good afternoon, everybody now. I didn't quite get in yet. So, again, my name is Michael Villarreal, and along with my partner, Catherine Pollard, we represent the state of Texas. So I'm going to spend hopefully the next 45 minutes talking with you about the law and the law applicable in this case. Who here, when they got their jury notice in the car, thought this in the mail? Your jury summons, right? I never get a yes on this answer. Like Judge says, we're in here probably every other week choosing juries, and I've yet to have somebody like, I actually like jury duty. So I use it to say thank you for actually showing up, because without jurors, we're unable to pick juries, keep the cases tried, and I'm sure Mr. Morales appreciates you being here as well, so that he can get his case tried as well. So, what is the purpose of voir dire? It is to pick a fair and impartial jury. So I use this image to help illustrate that. Who knows who this is? Okay, I have a bunch of cards up. Let's see, number 5. Who is this? Willie Nelson. Willie Nelson. And what does Willie Nelson love? I mean, it's in the picture.
Marijuana.
Yes. Okay.
Oh.
And country music.
And country music, yeah. So Willie Nelson loves weed. I don't think that's any news to anybody. I think he in fact smoked weed on top of the White House. There's alleged. So is Willie Nelson going to be a good juror for a case, let's say, a possession of marijuana?
Nope.
No, right? Because he just doesn't agree with our laws, right? Yeah, I'm sure he understands them. He's just like, I like my weed, guys. So does that mean Willie Nelson's going to be a bad juror for, let's say, a murder case?
No.
An assault case? No, right? So I use it to illustrate. This is the one time you get to give your opinion to a lawyer and a judge, and we're not going to argue back. So we just need to know how you feel about the law, how you understand it, if you don't understand it. And it's okay to say, if this is true, I understand the law, I just don't agree with it. And if I don't agree with it, I won't follow it. Okay. So don't try this with your spouses or loved ones at home. For those who are maybe not as visual, but more like my brother, those math types, I like to think of this as an equation. A fair and impartial juror is somebody that can follow the law that the judge is going to give to you at the end of the case. And then base your decision only on the facts of the case.
Yeah. Alright.
You didn't miss much.
There was another panel up there and I wasn't sure. Sorry.
Did I not tell everybody about the other jurors? Oh, that's okay.
And I also use this to say, I know that there was a lot of smiling faces when you first entered here, and then when judge said what type of case this was, those faces changed. Unfortunately, child sex abuse is very pervasive within our society. There's a study from a long study, it's called the Adverse Childhood Experience Study, which says that 1 in 4 girls and 1 in 6 boys are to experience some type of sexual abuse in their life. So, I mean, statistically speaking, if you look to your left, you look to your right, look behind you, look in front of you, you know somebody who has been a victim of sexual abuse. I say that just to go on to, unfortunately, you know, if that were the case, if you know somebody who was, and that would automatically make you an unfair or impartial juror in this case, then we wouldn't be able to try these cases. So what I'm asking from you is, if you can be fair and impartial, what that means is, I might have an experience, but I can set that aside and I can just look at the law and the facts in this case, okay? I'm gonna circle back to this later in the presentation. I just kind of want to plant that seed right now, okay? All right, so Judge already talked about this, beyond a reasonable doubt. So we can't tell you what it is, but we can tell you what it's not. So it's not proof beyond all doubt. It's not 100%. And again, possible doesn't always mean reasonable. Right? Is it possible that something happened? Sure. I think we can never, there's very few times we can't say something is impossible, right? Is it possible that the sun will fall out of the sky tomorrow? Yes. Is that reasonable? No, right? You've been waking up for however many days old you are, and it's the same place, right? So again, possible doesn't always mean reasonable. And reasonable doubt only applies to the elements of the offense. So if you are a juror on this case and you have a reasonable doubt as to whether the defendant was wearing a blue shirt or a yellow shirt on the day of the offense, that's not an element of the offense. So it doesn't go to an element. So that's okay if that is your reasonable doubt, so long as it doesn't go to the element of the offense. Does that make sense to everybody?
Yes.
Does anybody have any questions on that? So back to, I like pictures, and I'm just a visual type learner. Who here has dogs? Let's show first. All right. Who here who has dogs has come home to a scene like this? Okay. Jury number 4. Tell me what happened.
Did we left the bag even? That also had dropped it on about front of the trash cans, that the rest left the bag at the bin. And then themselves, the little stems of the chocolate.
I mean, can't blame, right?
No.
So were you there to see it happen?
No.
But you know beyond reasonable doubt.
Yes.
Right? So I go use this to illustrate, you don't have to be there to know something happened beyond a reasonable doubt, right? Because if you were there, you wouldn't be sitting here as prospective jurors, you'd be a witness in this case, right? So you don't have to be there to know something happened beyond a reasonable doubt, right? You have to look at the facts and circumstances around it, okay? Does that make sense to everybody?
Yes.
Does anybody have any questions about it? All right. Yes, number 12.
So if I had kids, I could consider that a reasonable doubt.
Right, so you look at the facts and circumstances, right? If you had kids, maybe, right? Your
If
kids
they
like
were
to,
home and stuff, and they're in trouble, could that be considered reasonable?
if they were what?
If I had kids and they were home at the time,
I mean, that's up to you to make that determination, right? Your kids like to eat the steady parts of the strawberries. Right, so in that case, maybe it's not reasonable, right? But that's for you to make a determination about the evidence, right? Does that make sense? Anybody else have any questions? Okay. So, these are the elements that the state has to prove in this case beyond a reasonable doubt. And this is for continuous sexual abuse of a child. That the defendant, who is 17 years of age or older, during a period of 30 days or more, committed 2 acts of sexual abuse to a child who was younger than 14 years old by committing these predicate acts. And I'm going to talk about these predicate acts in that way because it's just easier for me to frame it that way. But these are, he did all of these things within a period of 30 days or more, at least 2 times. So committing an offense or offenses of aggravated sexual assault of a child and or committing the offenses of indecency with a child by contact. So there's actually 4 predicate acts alleged in this case. I want to go through with you. The first predicate act is aggravated sexual assault of a child, which in this case is alleged that he intentionally or knowingly caused the defendant's sexual organ to contact the child's penis. That's the first predicate act in this case. Second one is, again, another different type of aggravated sexual assault of the child, that it caused the defendant's organ to contact the mouth of the child. The third act in here is that he caused his finger to penetrate the sexual organ of the child. And the fourth one is indecency with the child by contact, which he engaged in sexual contact, and I'll go that pretty quickly with you later, with the child by touching part of the genitals of the child. And he has to do that with the intent to arouse or gratify the sexual desire of any person. So I kind of blew through these, but a lot of these are common sense. And I should also start with, we're going to be talking about some deep subjects today about body parts and things like that. So I might try to make jokes during this to make it light. I understand that these are serious things, but trying to make this not as painful as possible. So hope you don't think that I'm not taking this seriously. It's just a matter of sometimes it's just easier to talk about these things in that way. Okay. So the predicate acts. Our law is that you do not have to be unanimous on which specific predicate acts occurred, meaning you can, as long as you believe 1, 2, 3, or 4, and they happened at least twice in a period of 30 days or more, then you're fine. So if somebody say, well, I think it's just the first predicate act of contacting her anus with his sexual organ. And then another one thinks, well, I just think it's a second predicate act. So long as you agree unanimously that one of them has occurred at least twice, then you are unanimous. Does that make sense? You don't have to agree on the exact date when those acts occurred. So we'll talk about on or about language, but also specifically in the statute, you get a range of time as it happened. So long as you agree that it happened within 30 days or more, during a period where the child was at least with less than 14 years of age or younger, and the defendant was at least 17, then you're unanimous. Does that make sense?
Yes.
Any questions on that? So you do have to agree unanimously that the defendant committed 2 acts of sexual abuse, and those are at least one of those 4 predicate acts. So you could say, I think 1 and 2. Predicate act happened once, and predicate act happened 2. They were at least 30 days apart. That's unanimous. Another one could say, well, I think the first predicate act, he did that twice within a period of 30 days or more. And that's a unanimous verdict between those 2. Okay. And then again, you have to agree that the predicate acts, 2 of them happened within a period of 30 days or more. So basically a month. It has to be at least a month apart. Does that make sense?
Yes.
Okay. So I kind of explained this already, and this is just kind of laid out in the 1, 2, 3, 4 again. So one juror could say number 1 happened twice, and it happened in a period of 30 days or more. And then the second juror could say, I think 1 and 3 happened beyond a reasonable doubt within a period of 30 days or more. Those are unanimous verdicts. Okay, does that make sense?
Yes.
I hear oh, that was
Oh,
5.
so everyone, just so you know, sometimes there may be people coming in from this door and they're coming in from that door because they don't realize and they haven't read the sign that says we're in jury trial. And some people who are coming from this door, they're coming in to see me about different documents I need to sign, but it's unrelated to this case. All right, state.
Thank you. That was that had probably a second word after it. Probably a 4-letter word. All right. Next thing I want to talk about is our honor about language. So how it's alleged that honor about these certain days within a period of 30 days or more, this act happened. So the law is that the state does not have to prove the exact date, only that the date was prior to the indictment being presented. So as long as the act happened before we indicted it, then we've met our honor about language. It might seem a little weird, but let's think about it in the context of child sex cases. Why might that be? Think about kids. Number 4. Right, so they might not be the best historians about dates, right? I mean, it's fair to say I don't have any kids. I just have dogs that act like kids. But I have nieces, right? They remember certain dates, like their birthday. I always remember that one because they're expecting gifts, but they're not always best about the dates of when things happen. So does that make sense to everybody?
Yes.
Okay. Does anybody have a problem with the fact that we are able to allege this as honor about and the law? No. Okay. So sexual contact, that was for the indecency predicate act, and that's just touching, including touching through the clothing. So it can be, doesn't have to be skin to skin, it could be skin, clothing in between, of the anus, breast, or any part of the genitals of a child, or any touching of any part of the body of a child, including through clothing with the anus, breast, or any part of the genitals of another person. It really just means touching of these body parts, whether it's skin to skin or it's even over the clothes. About these certain body parts, the breast, anus, or any part of the genitals. Okay. That makes sense to everybody?
Yes.
All right. So we can talk a little bit about evidence in these types of cases. First, testimony is evidence. That is, testimony is what people are going to tell you off of the witness or on the witness stand. So that's evidence in this case. If you were to make this jury, you are going to be instructed that you are to determine the facts of the case and the credibility and weight to be given to the witness's testimony. Meaning you get to determine whether you believe of everything of what somebody's saying, some of what they're saying, or nothing of what they're saying, right? But you get to consider that as evidence and treat it like any other piece of evidence, whether it's physical, evidence, pictures, videos, whatever it may be. You get to treat it like any other piece of evidence. Okay. So, talking about these types of cases, what kind of witnesses would you generally expect to have in a child sexual abuse case? I'm sorry, what are you reading? Do they outside?
Yeah.
Juror number 16?
The actual child.
The child, right? Okay. Juror number 21?
Parent.
Parent, maybe, right? Juror number 68?
Behavior of the child.
The behavior of the child. Okay. You could stand for me too. 65.
Siblings.
Siblings, maybe, right? Juror number 10?
Like she was saying, not only behavior, but whatever presents in the body, maybe abrasion or redness.
Okay.
So maybe physical sign.
So maybe physical aspect of the case. With that, where does child sexual abuse usually occur? Anywhere. Juror number 33, you can stand for me.
In the home.
In the home, right? Juror number 68, the family,
Family, friends,
all right?
close friends.
So is child sexual abuse usually out in the open, or is it usually behind closed doors? Behind closed doors, right? So because the defendant or whoever the abuser is, they get to choose when, where, how these types of offenses occur. How many witnesses, meaning people who saw something, do you think could actually be able to testify in these types of cases? Not many,
Just one.
27, just one, right? So if it happens behind closed doors and it's just the defendant and the child, we might not have any other witnesses to tell you what happened. Does anybody have problems with
I'm
that?
going to object, Judge. I don't mind him saying the defendant was there, but he's getting on to whether my client can testify or has a right to remain silent.
All right, ladies and gentlemen of the jury, just remember, or of the panel, just remember that these are all hypotheticals. None of what either party is saying is about any specific facts in this case. You won't know what this case is about or what any facts may or may not be in the case unless you're on the jury. Does everyone understand?
Yes.
Again, he has a Fifth Amendment privilege not to testify. So what the state can present to you is evidence. Can't call him as a witness. We might only be able to have one person tell you what happened, that being the child. Does anybody have a problem with that? No. Okay. So I want to talk about credibility of.
Sorry, I guess I have a problem with that. How come there's not, in cases like that, how come there's not, psychologists, psychiatrists, I don't know, whatever the psycho part of it would not be, considered to be able to testify after speaking to the child and with their knowledge and whatever.
So, and what I mean by this is that might come, you might get evidence of that, you might not. But I'm talking about people who were there who saw it, right? That there might not be anybody else to tell you, I was there and I saw these things happen, right? That's what I'm talking about. I'm not saying we might not call any other witnesses, right? You might hear from police officers, you might hear from medical, you might hear from a bunch of different people, but sometimes the only person who can tell you is the person who is there, and that'd be the child. Make sense?
Yes.
Okay. Is that clear, anybody? Okay. Good. So, I want to talk about credibility of the witnesses. So I already briefly touched on this, that you're going to determine the credibility of the witnesses. What types of things do y'all look for when determining the credibility of witnesses? Or I would say witnesses, because I don't think some of y'all have been jurors before, but when you're determining the credibility of when you're talking to somebody, whether it's a coworker, a family member, somebody you just interact with, what do you look at when determining the credibility of those people? Juror number 21.
Corroboration.
Corroboration. Juror number 16.
Their body language.
Body language. Number 12. Consistency. Juror number 74.
Past events. I didn't hear.
If you could stand for me.
Event.
Okay. Past events. Juror number 10.
Historical record.
Historical record. Number 14. Detail. Okay, I think y'all touched on that. Juror number 57.
Relationship to the defendant or
Right, the relationships between people, right? So I think a lot of y'all talked about, kind of touched on these, right? Demeanor, their body language, how they're acting. Motive, I think this kind of touches on what you have to say, number 57. Do they have a dog in the fight? Do they have a reason to be saying something that they're saying? Do they have something to gain by saying what they're saying, or something to lose by not saying something? What they say, I think maybe 10. Talk about like just what they say. Does that even make sense? And then consistency in statements. So I want to talk about consistency for a little bit. Who here likes to go to Fiesta? At least before COVID. Okay, I see some cards up. So I'm a native San Antonian, born and raised here. And so I had a family tradition is every year we used to go to the Battle of Flowers parade. It was a very specific sequence of events. Church's chicken, go get our seats, eat, and then watch the parade. And it happened year after year after year. And I always go with my aunt and uncle. So let's say this last year, I went to the parade, and after the parade, I tell somebody, oh, these are the floats that I saw, and I remember seeing these things. And then 6 months later, I try to tell those same details to my mom or dad. Do you think I'm gonna necessarily be consistent about all of those details? No, right? I mean, things can change, right? Let's say I'm an adult and I have some adult beverages there. Is that? My spouse probably thinks I am. Might that change my consistency? Right? Does that mean that I wasn't there?
No.
Right, so consistency, I use this to say consistency can be something that you can look at in terms of credibility, but it doesn't always necessarily mean that somebody's lying. I like to also think about this, my football fans, if you don't know already, I'm sure you'll find in this trial, Judge Boyd's a huge LSU fan. So she can tell you all about their record and their games. But let's say in the context of a football game, if you let's look at 3 different people and see if they would necessarily be consistent. You think a player, a ref, and a spectator are all going to be able to tell you the same story about a play?
No.
No. Why? Different point of view. Juror number 16. Right? I'm sorry, juror number.
Impression of what happened, you might have something that stays in your mind. That would be.
Judge Boyd is very fair, but she might have a different view on a bad call on an LSU game versus a Florida Tigers game, or against the Florida Tigers, right? So also maybe you're looking for certain things, right? And a rep is going to be looking for different things than necessarily a spectator is going to be looking for, right? So they might catch different details.
Favoritism toward player.
I'm sorry?
Favoritism towards the player.
Right? So that can change what you might see or be looking for, but does that mean that they weren't there? Right? Okay. Does that make sense to everybody?
Yes.
Does anybody have any questions on it? Okay. If I could have a show of cards, who here has been a victim or knows somebody who's been a victim of sexual abuse?
Or somebody that's been accused of it.
Talk about victims. Okay, if you could keep your cards up for those who immediately outcried about what happened.
They what?
If you keep your cards up, if that person that you know or you, that person immediately outcried about what happened. Right, I think I see 4 cards up out of those 5 cards up out of those number of cards, right? And you can put your cards down. Do you think that children who have been sexually abused always immediately report what happened?
No.
Why not?
Scared.
Okay, I get some cards. Juror number 10. Run and stare. 16. Scared. Juror number 27.
Disbelief.
Disbelief. Number 23. Confused. Number 28.
They think nobody will believe them.
Nobody will believe them. Juror number 35.
They believe they're at fault.
Wait, so they have to take blame themselves. Juror number 20.
Scared or threatened.
Scared or threatened. Juror number 55.
They're scared that they're gonna be blamed for something that.
All right, everyone, if you're not on that row, please stand so that Brenna can hear if you're able to.
I'm sorry, I'm usually a rule follower. Remember,
They're
remember.
scared that they got, victimized like that.
Okay. Juror number 11. Embarrassed, ashamed. Juror number 57.
It was probably done by a family member or a friend.
Okay. Juror number 64.
I was gonna say shame.
Shame. And juror number 68.
They're afraid, they'd be afraid to be punished.
Afraid to be punished. Juror number 74. If you could stand for me.
Denial.
denial. I think a lot of you already touched on a lot of things that, you know, I hear typically in these types of cases. So. These are previously kind of some of the things I've heard from jurors, right? They don't know that the acts were bad. Some of them think that the abuse is love, like it's normalized for them. It was fun, it didn't hurt, right? They thought it might have been a game, they didn't know any better. A lot of you touch on this psychological manipulation, like they're threatened or bribed, feeling helpless. I think a lot of you touch on this one is like no one will believe them. And sometimes that might be because mom or dad or whoever's in charge of them are not didn't believe them. They're not very supportive of them. I think juror number 50, 35 maybe talked on feeling responsibility and guilt and kind of taking that blame on themselves. I don't think anybody touched on this one necessarily, but protecting a parent or family member, right? They don't tell anybody because they don't want that family dynamic to necessarily change. So just, do this to consider things of why children might not immediately tell what happened to them. So I want to talk about, some of you have kind of touched on physical evidence in these types of cases. If sexual abuse is reported right away, or in those cases, let's say an immediate report, do you think in those types of cases we are always going to have physical evidence? No. Why is that?
For one,
Condoms, right? It could be some prophylactic,
cleaning up afterward as well.
I didn't repeat that.
cleaning up
Clean up
afterward.
Okay.
Anybody else? Juror 12?
Just because people may not know the type of process.
Juror number 4? Right, I think, see juror number 9, shake your head.
Yes.
Okay,
Depending on the time.
right, so like, but let's talk about the indecency part of that, try to get at, just touching. Whether it needs to be overflowed. Do you think we're necessarily gonna get physical evidence on those cases? So. Would anybody require the state to present some type of physical evidence like DNA evidence before you could be convinced beyond a reasonable doubt that this happened?
No.
Okay, if you do, I need to know now. So I want to talk about kids for a little bit. Obviously, this is a child sexual abuse case, and so you might be hearing from a child. I know I have your juror cards, but who here has children? A lot of, I went through and I usually have lots of people have kids. It's like highlighting everybody. That's great. So with that, who here has young kids, kids that are in school right now? I'm gonna use juror number 18. Do you get to talk to your kids after school?
Yes.
Okay. Do you ask them about their day?
Yes.
Do they always tell you in chronological order about their day?
Absolutely not.
Okay. Right. When you ask them how their day is or how it went, what are the things they type of things that they tell you?
They usually start with recess or lunch.
Right. I'm assuming they're probably like me, like their 2 favorite subjects, right? And kind of already touch on this a little bit. They don't tell you, first period or my first class was this, and then my second class was this, and my third class might have been this, right? In order.
Correct. No, I usually have to draw that out of them.
Right. So fair to say kids are not always the best historians about chronologically what happened, right? What typically are they going to tell you? Like the highlights of their day, right? The things that made them happy, the things that made them sad, maybe things that frustrated them, things that we're looking forward to, but they're not always necessarily going to give you the mundane, like, we read X book today, right? So in that, if your child doesn't tell you everything that happened that day, does it mean that they didn't have any type of day at school?
No, they definitely had a day at school.
Right?
Uh,
Doesn't mean they didn't go to school, right?
Right, if you're dropping them off and picking them up, they were there some capacity.
Doesn't mean that they're not telling the truth, right?
Correct.
So he's talking about this is kids, they're gonna tell you some highlights. They're gonna remember things that were important and not, but they're not always gonna give you stuff in chronological order. And so it's hope that you look through that in the lens of a kid, right? When they
15
might be
minutes.
Telling you about what happened. I'm sorry?
15 minutes.
15, thank you, Judge. Talking about demeanor of kids, to talk about them on the witness stand. Do we, let me put it this way. I'm not actually gonna do this, but who here would like to tell me about their first sexual experience? Right, but thank you.
There's someone behind us.
All right, I got a smart one in every crowd. I want to say no thank you to you, Freddie. Right, and that's what we ask a lot of these kids to do when they take the stand. They're gonna have to tell you about the first time somebody touched them, and in many cases, it might not be a consensual touch, right? Kids can't consent, but that's not an issue in this case, but meaning that it might be something that they fought off or, were vehemently opposed to happening to them. They might have to take the stand and tell you about those things. You expect kids to act a certain way when they're testifying. Yes. What do you expect them to look like?
Intimidated, scared.
Okay. I have a little, I'll call him little brother. He's not so little no more. Jacob, and every time he gets like nervous, he starts laughing. Right? And he gets that real nervous, giddy laugh, right? If fair to say some kids might react that way. Sure. Right? So, turn number 21.
That's what I would say is that I have no expectations of how a child might look when they're being asked those kind of questions. They'll
Right.
have all different kinds of reactions.
I think it's fair to say, there might be a range. I might expect them crying or something like that. But is there anything like they're not believable unless they're crying? They're not believable unless they look scared. All right. So, and I go on to say, are all child sex abuse victims the same?
No.
Do they all react the same way? They all look the same. You all testify the same way. Is there anything you think that makes the child maybe necessarily more vulnerable to being abused? What types of things? Turn number 27.
Shy person.
Turn number 35. You can stand for me.
Broken homes.
Broken home, right? Turn number 14. No caretakers. Turn number 4.
You're still learning, you're ignorant. You don't know what's right and what's wrong. You're still being taught that. So when they're pressed, those are not even said, they're gonna.
Turn number 12. Use your card.
Well, if they're just, often put in the position where the opportunity exists for predator to maybe.
Turn number 5.
The amount of time they're unsupervised.
Okay. Turn number 44. Actually, that's on it. Okay. Turn number 20.
Child might be handicapped.
Right. Turn number 41.
May not be believed.
Might be believable. Turn number 73. You stand for me.
They're very trusting,
Very
or
true.
they don't know better.
Okay. So I use this slide to talk about some of people who are self-identified child sex abuse victims, and that they don't all necessarily look the same way or act the same way. and Oprah, Tyler Perry, Ellen DeGeneres, Carlos Santana. This is America Ferrera. I've been ready for a while. Axl Rose. This is a more obscure one, but if I have some Shawshank Redemption fans out there, this is Rita Hayworth. Mike Tyson. So it's fair to say child sex abuse victims don't always look the same, right? Want to talk about children in the line. A lot of y'all have kids, so I'm sure y'all know. Why don't you ask the way? Do children lie?
Yeah.
Okay, right? Of course they do. Do they usually lie to get into trouble or out of trouble?
10
Jim?
minutes,
I'm sorry?
10 minutes.
Thank you, Judge. Do they usually lie to make their lives easier or more difficult?
Yes.
Easier, right? What types of things do kids generally lie about? I'll touch back on you in a second. Turn number 9.
Great.
Great. I've done that once or twice. Turn number 5. Brushing their teeth. Brushing their teeth. Yeah. Number 53.
They might lie, they don't know, like they don't remember and they just say something.
Right. Those white lies. Turn number 33.
Interactions with the sibling.
That's a very nice way of putting that, right? Fight with their brothers and sisters, right? Like who hit who first. Right. It's fair to say everybody here has known a child to lie, right? Do kids typically lie about being sexually abused? No. Do adults lie?
Yes.
Right? Well, I think we talk about all things adult lie. A lot of this, not necessarily brush their teeth, but lie about a lot of the same things, right? Maybe their work performance grades, right? Whether they're getting along with their spouse or their kids, right? They might lie about things like that. So again, just because a kid doesn't mean that they're necessarily just by being matter of fact being a liar, right? So evidence. We don't have any eyewitnesses and we don't have any physical evidence. How do you prove child sex abuse cases? How do we as a state? How do you think? Turn number 50.
Consistency.
Consistency. Okay. Jury number 68.
Children's grades.
I'm sorry?
Children's school performance.
Children's school performance. Okay. I'm thinking it's probably an easier answer than both of those.
Change of the child behavior.
Change in child's behavior. Jury number 65. Emotional. Jury 53.
Testimony from the actual child.
Yes, right. A lot of these cases, again, I know I'm probably beating a dead horse, but a lot of these cases we pretty good. Should we prosecute child sex abuse cases if we only have the word of the victim?
Yeah.
Now, when we put this reverse, who thinks we shouldn't prosecute child sex abuse cases if we only have the word of the victim for the child? Jury number 53.
I just think it depends.
Okay. Anybody else?
If the child has been proved to be a liar.
I'm just talking about generally. I'm not going to give you one of these hypotheticals. I'm not going to give you necessarily anymore. Jury number 12.
That's the only thing you have someone saying this happened. I think there's gotta be a bigger perspective, more pointing to wider credibility of what you
Thank you. Anybody agree with what number 12 stands?
Yes.
You can show a card. Can you repeat what you card saying? Turn it up. Can you repeat what you said again?
It can't just be only pay for me, a child saying something occurred. My brother hit me. That doesn't mean your brother hit you. You gotta have some other, something to correlate with that to in my mind to say, okay, that makes sense, that's reasonable, that occurred.
Okay, everybody hear that? Okay, who agrees with number 12? I have 1, 5, 6, 9, 10, 11, 16. I'm gonna put you on 18, 20, 23, 25, 33, 37, 38, 40, 44, 45, 51, 53, 55, 58, 59, 61, 65, and 67. All right, let's get through these. I want to talk about punishment really quick. So you are going to be deciding on whether, if you find him guilty, the punishment of what should be assessed in this case. So these are the ranges of punishment for all of these types of cases. You
5
might-
minutes.
Thank you, Judge. You might be considering the lesser included, which are aggravated sexual assault of a child and indecency with a child. Judge already talked about range of punishment with y'all, and so I'm not going to cover that anymore. It seems that everybody can consider the range of punishment. Has anybody changed their mind from what the judge covered with you as far as range of punishment? Okay. All right, this is a quick scale question, and this is, I can get a, were you raising your part 12?
No.
Okay. A quick snapshot from you. So I'm not saying that on this question, what's the purpose of the sentence? Meaning the punishment. That you have to be all one or all the other. This is which one do you more identify with? So I just might slightly lean this way a little bit, or I might slightly lean this way. You might be a little bit of both. I'm a little bit of both, right? So this is which one do you more identify? What's the purpose of the sentence? Number 1 is punishment. The defendant needs to be punished for the consequences of his actions, or 2, rehabilitation. I need help. I need to help the defendant from reoffending. So again, what's the purpose of a sentence? Number 1, punishment. The defendant needs to be punished for the consequences of his actions, or 2, rehabilitation. I need to help the defendant from reoffending. If I show of cards, who falls into category number 1? I see 1, 2, 3, 9, 11, 12, 13, 15, 18, 20, 21, 22, 23, 24, 27, 28, 29, 30, 31, 33, 34, 35, 36. Can you turn your card around for me? 38. Did you have your card, sir? No. Okay. 38, 44, 45, 46, 48, 49, 50, 51, 52, 53, 54, 55, 56, 57 through 60, 64, 66 through 70, 72 through 75. Okay. I just want to follow up really quickly on some of the one thing that Judge had talked about with you, juror number 44. You're going to Vegas, right?
Kind of,
Nashville. 2 you'll go to. When you're leaving Friday?
Friday morning at
What time do you come back?
Monday.
Monday evening. Okay, that's what I needed to know from you. Okay. With that, I'm gonna try to give Judge like 30 seconds back. Does anybody have any questions for me? Anything that I need to know about you or you being a juror on this case that we had not already discussed? Juror number 3.
Yeah, who the detectives have with you?
Are you with law enforcement? Okay, what agency? SAP. I missed. What's your number 3? Okay. What unit are you in? Okay. It would be an SVU detective. You work with a lot of SVU detectives?
Yeah.
Okay. Would that change your opinion about whether you could be a very partial juror depending on the detective? Okay. Thank you. Anybody else?
Question.
Yes, sir.
Whatever my religious beliefs, that I shouldn't judge anyone.
Okay. Is it a certain, like, organized religion that you follow? Meaning like, I'm a Jehovah's Witness, or I'm a Catholic, or I'm,
It's non-denominational.
okay. So based on your faith?
Mhm.
Okay, thank you. Number 24, that sounds serious? Okay,
have the paperwork from work.
okay, and does that change your ability to be here?
It changed, yes, I don't have a seat.
Okay. Okay. Okay, we're gonna talk to you. Turn number 61. You can stay for me, I'm sorry.
I'm just paying wages, so if I don't go to work, I need to pay 90 days.
Okay,
All right, that's time.
all right, thank you guys. Appreciate your time. Look forward to working with both of you.
Maybe approach that.
Yes. We're just going to take a 2-minute break. So if everyone can stretch, because we just need to someone to take a short break. So you can move around and stretch a little bit.
We had discussion number specific.
All right, defense, are you ready to proceed?
Sure, I'm ready.
All right, you may proceed.
Thank you, man. Support. Or counsel, ladies and gentlemen, of the jury. I'm Anton. This is my part of the jury trial. And you're going to have a jury trial. And I know that most of them have never been in a jury trial, but as the judge said, and I agree, it's a very important part of our democratic freedoms here. Right. This case is difficult. I don't know anybody that's not a pedophile and doesn't say, I like to abuse children. It's the other way around. Nobody likes to abuse children, sexually or physically for that matter. So when you try a case where a young child says, this person did something to me and it's wrong, it's very difficult to stay with your oath that I'm going to listen only to the witnesses and the facts and make my decision, because it tugs on our heartstrings. I understand it. Every case, as a felony, has an indictment. Don't know if to be given a copy of the indictment, will be read to you. And it talks about the predicate facts that Mr. Viral talked about. But it also has a date of range that this occurred from the 15th of September in 2011 through the 15th of January 2014. It's 28 months. And then the state has the right to depend on or about, and especially in a, I hate to say kitty sex case, but this type of case, people may not remember. I mean, sir, where were you September 15th of 2011? Do you know where you were? Do you know where you were? Do you know?
I know exactly where it was,
Where were you?
burying my husband.
Oh, okay. But that's a standout event, isn't it? You're not going to forget that. You're not going to do it every day. It's not something usual. Yes, I was burying my husband. Thank you for sharing. So this offense, if it occurred in a more than 30-day period, happens maybe in 28 months. Now, what's the problem with that for me? This is supposed to tell me what I have to defend my client against. And that's a big time to defend against. And to have this person remember this happened one day, this happened someday, or it was cold outside because it was winter, or it was warm outside because it was summer, or I just gotten out of school, or just had my birthday, or something to kind of see where these dates are to defend against. And suppose if somebody just saying, well, this was done to me. I'm sorry, I'm just lost here a moment for a second. Okay. You are the judges of the facts proved, not the law. The judge will give you the law. And I want everybody to promise me you'll listen carefully to whatever the witnesses or testimony or evidence has and make your decision from that. Now, does everybody believe we have a right to a jury trial?
Yeah.
Good. Okay. If you've been to the penitentiary before because you've been a bad boy and you got a felony conviction, do you still have a right to a jury trial?
Yeah.
Okay. Now, if somebody had a felony conviction and wanted to take the stand, let me see how it phrases. You can take that in your mind as maybe being something to say that person is not truthful, but would you automatically say that person is not truthful because they had some prior event? Just tell me, if anybody wants to say that automatically, it's okay. Well, thank you very much. Okay. We talked about children. Oh, you also found a secret about me if you went to lunch. I drive a wheelchair because I have PAD, peripheral artery disease. I'm like, right now I'm starting to feel odd, but I'll try not to fall down in front of you because it's just not that much fun. We asked if kids can lie, and I think everybody said children can lie. And they asked you a question, or the question was asked, will children lie about a sexual assault? Everybody said no. Now, how do you know that? How do you know that kids don't lie about a sexual assault? If you do.
Age and perhaps what they might get out of it.
Okay. That what we get out of it, it's a big nail, sir. You're very astute. Anybody else? Okay, so we know that kids can lie, they can lie about sexual assault. How many people have read about a recantation where somebody says, oh, you know, you find horrible things like that black guy was the murderer, and then 8 years later they go, well, I wasn't sure of all the black people which one it was. That's a recantation. Or how many, go ahead, did you listen?
No,
Or how many people say somebody did some, my brother hit me. This person took my toy or whatever, it's kind of simple, because my child's 40 years old. And it's just not true. But sometimes people recant what they say, and you have to be able to determine if they're telling you the truth or not. So. Mr. Villarreal went through the predicate questions. I'm not going to go through that all again. There's different ways to commit an offense, but lesser included offenses are actually different offenses included in the general scheme of things. So there's continuous sexual assault. And I'm in favor of that offense. If somebody is doing something to some person on a regular basis, to me, a regular basis, like weekly or monthly or something, it's not twice. That's me. I don't have to like the law. But I think that's wrong. I've never seen a little girl, little boy that I wanted to play with that way. I can't understand why anybody would like it. It took me a long time to realize I am physically unable of understanding why anybody would want to commit a sexual assault offense. Just can't figure it out. How many people know about the evil mother-in-law or the evil grandma? That's kind of an open question, wasn't it? You're shaking your head. There are some, they don't like who their daughter married or who takes up with or something like that. And can they plant seeds in the children's minds? Come on, you gotta stand up now, you can smile, raise your card. You and the green top. Can evil mother-in-law, the evil grandmother try and persuade a child that something happened, whether it did or not? And that child will believe it. Right. Depending on the type of offense, there's different type of offenses. This particular offense, I think you're going to hear a defense called alibi. An alibi means basically I wasn't there, it wasn't me. So how do you prove you weren't there? You don't have a picture of you not being there. It's got to come through testimony. Because people maybe y'all have a problem with relatives testifying for relatives, the victim and her mom, the mom of my client. Anybody have problems with that? I mean, there aren't police officers on every corner. We can't always have the best information. My client has a right to remain silent. I've already kind of given a hint of why he might like to do that. But we all have different reasons for what we say and what we do, and I represent the best defense I can. So does anybody have a question for me right now? Oh, come on, guys. There you go. Number 10.
The victim, when did she, how old was she when she reported?
11?
No, excuse me.
Oh,
You're not allowed to know any facts of this case. The only way you would get facts on this case is if you are on the jury. Both the state and the defense are going to only be talking to you about hypotheticals.
I'm sorry, Judge.
That's okay.
I just get carried away. But you saw a slide that said she's under 14. So if the slide was it, that's answered right now. Yes, sir, Mr. Clark.
No, I would just say you brought up several scenarios where a child may be lying and relive the lie. In other words, and that gets back to my statement earlier that a statement alone cannot, in my mind, make beyond a reasonable doubt. I need corroboration to that statement or lack of defense to that. If there's defense to a statement, that would suggest that may not be true. That's going to influence my decision. Or my perspective, or what I think actually occurred, or the credibility of the statement. That's why it's more than just a statement on both sides, whether it's a true statement or not a statement. I need more evidence to suggest it is a true statement, but that's all that we have for evidence versus not a true statement. I mean, hopefully there's more evidence to make decisions. But
Well, I'm guessing the state might have some evidence. They certainly wouldn't want to try a case with no evidence.
well, correct.
So let me just leave
Question
that answer
was
there right there.
based on state law.
How many people feel it's a statement alone that they can't convict? 20, you can't convict you, you told us that. 64, 67, 68.
If there's
One,
If there's enough evidence to suggest that they're saying the truth, I can convict them for it.
that's inside.
Okay, yeah, just on the statement without.
And that's your job. You're supposed to find sufficient evidence to prove this case beyond a reasonable doubt. And I will let you know, I can prove beyond a reasonable doubt that every one of those wearing clothes. It's pretty bad, huh? I can probably make a learned guess that y'all have keys or a purse or a wallet. But I don't know if to be true. Any more than I know if you have a handkerchief or something else in your pocket. I know it's a silly, stupid example, but it's the best one I could think of today. And so you can have beliefs and you can make reasonable connections from the evidence presented, but at the same time, I want you to hold on to your verdict. If you're the only person in the jury room, you said this man is not guilty or he's guilty, everybody voted the other way, you hold on to your verdict. I say that now. It's tough. Okay. No questions. I have nothing else. Thank you very much.
All right, thank you. All right, ladies and gentlemen, I'm going to have you all wait out in the hallway, and we're going to bring you back in probably at about 3:30. Right? So make sure you take your personal items with you. Do not leave anything in the jury box, and just wait outside in the hallway and do not wander off. All right, everyone.
Are we allowed to bring drinks in or no drinks?
As long as there's a cap on it. All right, thank you. Everyone, please rise. Leave your numbers behind, please.
Okay, y'all gotta stand up.
I say because.
Where you can. Okay, have fun, see.
All right, everyone, just find a seat anywhere.
Just find a seat and then find a seat in each. Here. Next, sir, you can sit down, and you can sit down, please. Appreciate it, thank you.
It's 75 early. So we don't say anything like taking people out of turn, which is time.
Yeah.
Let it go to that.
I think I do apologize.
Okay, cool.
That's what she wanted. I think.
And then you can do your opening later. Are you gonna want to do the opening before your fingerprint person?
You're planning-
You do not speak the word you write.
Oh, yes, just sit anywhere.
Good, how you want, right? If you want me to put my person on very first, I will.
Oh, we're gonna do- I think we were both.
Rodney, the jury box.
Oh.
The jury box. Can't get a jury box. No, you're not gonna put them there.
You
No,
know.
not in the jury box.
Even if I-
They'll just have to stand in the middle.
Okay.
Yes, you all just have to stand in the middle.
Fingerprint will be quick.
All right.
You have to see me.
Thank you.
All right, everyone, thank you so much for your service. Again, we cannot have jury trials without having jurors, so your service is appreciated. You're always welcome to come to the 187th District Court, which is on which floor? And who's the judge? All right, and the court number?
187.
So the courtroom is open to the public. You're always welcome to come. You should be receiving in the mail check for your service. You can always donate that if you choose to donate that. Otherwise, what will end up happening is you'll probably receive a check in the mail probably 3 months from now, and you'll think, where is this coming from? And then you'll remember the great time you had with us. If you parked in the garage and you need your parking validated, you'll need to go back to the basement to Central Jury Room, and they will validate your parking. The deputy at the back will give you white sheets, and those white sheets signify that you were actually in court today and that you completed your service. So what I'm going to do now is I'm going to call the persons who will be on this jury panel, and I will need you to take a seat in the jury box when I call your name. Lucas Navarez, Patricia McDonald, Rocio Hernandez, Cynthia Goldman, Renee Hernandez, Lori Spear, Eric Van Bothel, Jacqueline Loden, Shanae Davis, Michael Ryan. Jana Valdez. Artisha Washington. Russell Gayton. Daniel Bolton. All right, everyone else, thank you so much for your service. You are excused. Before you leave, make sure you get the sheet from the deputy. Thank you. All right, ladies and gentlemen, after they file out, I'm going to swear you in.
Prefer the grandmother accident. Murder, right?
I like them nice and clear for the kids.
All right, ladies and gentlemen, I know you were given an oath downstairs, but I'm actually going to give you an oath for this specific trial. So if you all could raise your right hand for me, please. Do you and each of you solemnly swear or affirm in the case of the state of Texas against Mario Morales, you will a true verdict render according to the law and the evidence, so help you God? All right, you can lower your hand. State?
Proceed with reading the indictment, Judge.
Yes. Please stand.
True bill of indictment. In the name and by the authority of the state of Texas, the grand jury of Bexar County, state of Texas, duly organized and paneled and sworn as such at the July term AD 2019 of the 175th Judicial District Court of said county in said court at said term do present in and to said court that in the county and state aforesaid and anterior to the presentment of this indictment, Mario Morales, hereinafter referred to as defendant, did then and there during a period that was 30 days or more in duration to it from on or about the 15th day of September 2011 through 15th day of January 2014, when the defendant was 17 years of age or older, commit 2 or more acts of sexual abuse against a child younger than 14 years of age, namely, 1, the defendant did intentionally and knowingly cause the male sexual organ of the defendant to contact the anus of Sandy Sanchez, a child who was younger than 14 years. 2, the defendant did intentionally and knowingly cause the male sexual organ of the defendant to contact the mouth of Sandy Sanchez, a child who was younger than 14 years. 3, the defendant did intentionally and knowingly cause the penetration of the female sexual organ of Sandy Sanchez, a child who was younger than 14 years, by the defendant's finger. 4, the defendant did intentionally and knowingly engage in sexual contact with Sandy Sanchez, a female child younger than 14 years, by touching part of the genitals of Sandy Sanchez with the intent to arouse or gratify the sexual desire of any person against the peace and dignity of the state, I inform of the grand jury.
All right, how do you plead to that, Mr. Morales? All right, thank you. You may be seated. State, do you have opening statements?
Yes, Judge.
You may proceed.
So this is a very straightforward. The evidence you're going to see is going to show you a pattern of abuse. It's going to show you that the defendant was sexually assaulting a 7-year-old Sandy Sanchez, second grader. It's going to show you that the defendant, while he was sexually assaulting the 7-year-old, was actually somebody who should have been protecting her because he was her stepfather. And you're gonna hear from a few different people. One of those people being Sandy herself. She's gonna get up there, she's gonna take the stand, and she's gonna tell you what happened to her. She's gonna tell you what the defendant did. She's gonna tell you about the penetration. She's gonna tell you about the defendant forcing his penis into her mouth in her own home. You're also gonna hear from her mother, Brenda. She's gonna get up there and she's gonna talk to you about when her daughter finally came to her and told her what was happening. She's gonna talk to you about when her daughter finally came and told her what was going on with the defendant was out of their lives. She's gonna tell you you had nothing to do with the defendant, that the defendant wasn't bothering them. There was no reason to have any contact with the defendant at that time. You're also gonna hear from Dr. Spillers, who gave an exam to Sandy after she came out and said what was happening to her, what had happened to her. And Dr. Spiller is going to tell you that the results of that exam were normal. She looked at everything looked like a normal child. He's also going to tell you about the details of the abuse that Sandy told her during the exam. And you'll learn that a normal child, all the negative results of the exam and the details that Sandy told her are all consistent with sexual abuse because of the time since the abuse had happened. And you're going to hear from a Detective Bierman, and he was the investigator that was in charge of the case. So he had the case assigned to him, right? And he's going to tell you about that process, how the case gets assigned to him and what he does from there. And he's going to let you know that from there, he talks to different people involved with the case. So he's going to tell you that he talks to the defendant himself, talks to possible witnesses, looked at Dr. Spiller's report, and that after looking at all of those things, investigating all of the different aspects of the case, that he made the decision to file the case, so that the defendant needed to be arrested. And after you get all of this evidence, after everything you hear from all of these different people about this sexual abuse, I'm confident that it will still be a straightforward case for you. You'll go back, deliberate, and return a verdict of guilty.
All right, defense.
The defense will waive opening for later on, Your Honor, but I still have the agreement to take a witness out of the line.
All right, are we going to proceed with the defense's witness first or the state's witness?
We anticipated calling one state witness and then allowing him to put on his witness second. Judge.
All right, state, call your first witness.
Yes, Judge. State calls Roxana Rosas. And Your Honor,
Yes.
I would ask the court to invoke the rule at this time.
All right, the rule will be invoked. Ladies and gentlemen, and both parties of each side, if you have witnesses in the courtroom, they need to wait outside if they are going to testify. All right, if you'll take the stand here, please. All right, could you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can take the stand. Please keep your voice up so that the jurors can hear and the court reporter can hear.
Okay.
All right, state.
Thank you, Your Honor. Ms. Rosas, how are you employed?
Well, I'm a records identification supervisor.
Okay, and that sounds very fancy. Is there a more layman's term for what you do?
I supervise the fingerprint and ID section and the records section of the Bear County Sheriff's Office.
Okay. And with that, do you have any types of training or certification as it relates to fingerprints?
Yes,
And what is that?
I have the TCO certification for fingerprint identification and fingerprint classification.
Okay. And what does it take to get that type of certification?
Well, you take a 40-hour course over first the history and the definitions, and then the second part is the classifying using the Henry system.
Okay. So fingerprint examiner, is that a fancy way of saying you compare and look at fingerprints?
Yes,
And how long have you been doing fingerprint examinations?
before becoming a supervisor, 17 years,
And as a supervisor, how long have you been a supervisor?
about 4 years now.
4 years, you said?
Mhm.
And do you still do fingerprint examinations?
Yes,
Roughly, if you can you tell me how many fingerprints you've examined during your 21 years of this?
oh, gosh, I wouldn't know, 21 years of doing it. I'd say over maybe 10,000 or more.
Have you testified in court as it relates to fingerprint identification and fingerprint comparison?
Yes.
Although it's probably somewhat understood or commonly understood, can you just describe for the jury what a fingerprint is and what's special about a fingerprint as it relates to identification?
Well, a fingerprint is that part of the friction ridge on your hands that's left behind when you touch something because of the oils that are on your skin. The thing about fingerprints is every person has different minutia, short ridges, islands, dots, bifurcations that are different in each of the fingers. There's no people that have the same.
So a fingerprint is unique to a person.
Yes.
And what are you looking at when you're doing the fingerprint examination?
We're comparing each of the fingers and we're making sure that we have enough points that are matching, that those dots, those bifurcations are in the exact same location in each of the fingers.
Today, were you able to fingerprint the person who's sitting at the table next to me wearing a blue plaid shirt?
Yes,
And were you able to take legible prints from him?
yes,
And were you asked to compare that to a set of prints?
yes,
And did you complete that today?
yes, I did.
Your Honor, may I approach?
Yes.
Ms. Rosales, what's already in front of you? Is this the fingerprints that you took today here in court?
Yes,
And again, related to that person right there with the blue plaid shirt.
yes,
I'm going to mark this on the back for identification purposes as State's Exhibit number 1. I'm going to show you what's been marked as State's Exhibit number 2 for identification purposes. And specifically the 5th page of this document. Is that the set of fingerprints that you compared it to?
yes,
Were you able to, I guess today, the fingerprints in State's Exhibit number 2 were those legible prints?
yes,
And so were you able to accurately and fairly compare them to State's Exhibit number 1, the fingerprints that you took today here in the courtroom?
yes,
And is it your opinion that these fingerprints came from the same person?
yes,
And State's Exhibit number 2, which is a certified public document, relates to, is it fair to say that relates to defendant by the name of Mario Morales?
yes.
Your Honor, at this time, the state would move to admit State's Exhibits numbers 1 and 2, the tender defense counsel objections, if any, as previously tendered in electronic discovery.
Yeah.
Yes.
If that adequate opportunity to review these, I have no objections.
All right, states exhibits number 1 and 2 are admitted.
I'm sorry, no objections to state's exhibit number 1 and 2.
All right, states exhibits 1 and 2 are admitted.
Yeah, I'm sorry. I approve.
Yes.
And Ms. Rosas, you'd agree with me that this is a certified document from the Texas Department of Criminal Justice, the Correctional Institutional Division.
Yes,
And have you heard of a pen pack before?
yes,
Does this appear to you to be a pen pack?
yes,
And again, relates to contained in this is a judgment adjudicating guilt, right?
yes,
And it's a conviction for Mario Morales with for the offense of indecency with a child by contact.
yes,
And the sentence was imposed in February 5th of 2001.
yes.
Your Honor, at this time, the state would pass the witness.
Any
Thank you.
questions?
Is it Rufus? Is that your last name?
Rosas,
Say again.
Rosas.
Rosa, okay, sorry. I didn't understand your qualifications. You said you had 40 hours at T-close
Fingerprint, yes, a fingerprint.
and then
yes.
more identification. Was it like another 40 hours or 40 hours total or what?
It is 40 hours total.
Okay. Is that the only type of training you received?
No, I've also gone to more fingerprint training with the IAI, the International Identification Association, about a year or 2 ago. And there's other classes I've taken.
And are you required to like have a continuing fingerprint education?
No,
And looking at state's exhibit number 2, the pen packet, I thought fingerprints were very poor compared to state's exhibit 1 that you took today. How many points did you identify?
12.
And what is supposed to be the bare minimum to be correct?
The bare minimum is 12.
So there's no doubt in your mind that the fingerprints you took today match those in the pen pack.
No
State's
doubt.
exhibit 2. No further questions. Thank you. This witness can be excused.
Any further questions?
I guess not.
All right. All right, is this witness excused or subject for recall?
From the state, she can be excused.
She can be excused.
All right, excuse me, miss.
Thank
The
you.
rule, excuse me?
Oh, sorry.
That's okay. The rule has been invoked. What that means is you cannot discuss your testimony with anyone. The only persons you're allowed to speak to are attorneys for the state of the defense. Do you understand?
I understand.
All right, you're excused.
Thank you.
All right, is this the next witness? Is the out of order witness?
Yes, Your Honor, I'd like to call Michelle Morales,
Well,
please.
just one second.
I'm sorry.
Ladies and gentlemen of the jury, as I told you during voir dire, the state has the burden of proving their case beyond a reasonable doubt, and usually the state will put on their witnesses first. Both parties have agreed to go out of order. So Mr. Hayek is going to call his witnesses who would not be available if they would not be allowed to testify today. Does everyone understand? All right, Mr. Hayek, you may call your next witness.
Thank you, Your Honor. Michelle Morales, please.
All right. Could you see if Ms. Morales is in the hall?
Yes, and she's got that gene.
All right, if you'll take the seat here, please. Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth or nothing but the truth, so help you God?
Yes.
All right, you can lower your hand. Make sure you speak up so that the jurors can hear and the court reporter can hear. If
Okay.
you could state your name for the record.
Shah Morales,
Right, defense.
Thank you, Your Honor. And ma'am, how old are you?
41.
And the person seated to my right, do you know who this gentleman is?
Yes.
Name him.
Mario Morales.
And do you also know that he's the accused in this case today?
Yes.
And how do you know Mari Morales?
He's my brother.
So I know this sounds hokey, but you've known him all your life?
Yes,
And are you familiar with a young girl, or at least at one time, Sandy Sanchez
yes,
and her mother, Brenda?
Brenda.
Okay. And how are you familiar with those people?
That's his ex-wife. And his
Okay,
stepkids.
let's do it better. Brenda is the defendant's ex-wife.
Yes,
Now, is Sandy his
step,
biological child?
no,
So Sandy, well, we don't have to figure out where she came from. Okay. Now, you have been interested in this case, obviously,
yes,
and you understand talking about the time period that these more than 30 days have to occur.
yes,
Okay. And I'm going to go over it again for you. September 15th, 2011, the 15th day of January 2014. So I calculate that to be 28 months, but I could be wrong.
yes. I'm sorry, go ahead.
Do you remember or have a record of where your brother was during that time period?
In 2014?
Well, from 2011,
Oh.
September to January 2014.
Okay, yes, he was with me in 2011 from January to April. And he moved back with me in August to December of 2011. And 2012 from January to April, and he came back in October and December. In 2013, he was with me also in January through May. And in 2014, he was also living with me in August.
During that time period, did he ever reside with Brenda again, excuse me?
No,
If you know, did he have access to Sandy?
no,
If you know, did he have Sandy come spend the night or something?
no,
Did you ever observe anything of Sandy that would lead you to believe she had something to say, something she was hiding, something that caused her stress?
no. I knew she took medication.
Okay, well, do you know what medication she took?
Judge, I'm gonna object to the relevance.
All right, relevance.
No, it's not.
I'm
To
asking,
expect
what
your
is the
ability to Tell the
relevance?
truth and be
right, you
persuaded
can
by somebody else.
The objection will be overruled. You can ask.
Thank you.
the
Do you know what
question.
medication Sandy took?
No, not exactly what kind, but I knew it was to calm her down.
Okay. And so say calm her down. Do you know she was unruly in school?
That I don't
Judge, I'm
know.
gonna object to the
Okay.
relevance.
All right, that'll be overruled.
I'm sure I answered. What does she need calming down from, as you know?
Judge, again, I'm gonna object to the relevance.
That'll be sustained.
So, for example, when you're going through the dates, you didn't have every date chronologically, so direct your attention to May of 2012. And did your brother move in with your mother?
Yes,
So for 5 months there, you knew where he was, he just went at your house.
yes,
Correct.
yes,
And likewise, there's another period when he moves in with you. Is that correct?
yes,
And you indicate he moved in with you in August of 2011. Is
yes,
that correct? So
Yeah.
that would be the month before the first period of time. Did Sandy ever talk to you about any sexual assault?
no,
So do you believe that there was no chance for your father to commit the offense of sexual assault on Sandy?
Judge, I'm gonna
Your brother?
no,
Judge, I'm gonna object to the relevance and invades the province of the jury.
All right, that'll be sustained to the witness. When either side, either your attorney or the state makes an objection, do not answer the question. I'll make a ruling and then I'll let you know if you can answer it or not, okay?
okay,
All right, thank you. Objection is sustained.
Is it your testimony that your brother lived away from Brenda that whole time period that's in question, September 2011 through January 2014?
yes,
ask the witness. He might have some questions for you.
State.
Ms. Morales, what's your date of birth?
It's May 31st, 1981.
It appears you're reading from a piece of paper up there. What is that?
It's just notes that I had to remember, more or less the dates.
Your Honor, may I approach?
Yes.
When did you create these notes?
Excuse me?
When did you create these notes?
It's been a few months back.
Okay. And is this helping you refresh your memory?
Yes.
Okay. So,
And I have the address also.
so this
That's
is,
what helps me remember.
so if I'm understanding correctly, based on these notes,
Mhm.
in 2011, from January to April, he lived with you at Rosemont Apartment, which was located at 10127 Highway 16 South.
Yes,
Okay. And then in 2011, also he lived with you from August to December at that same location.
yes, sir.
And going on to 2012, is it your testimony from January to April and October to December? He lived with you again at that 10127 Highway 16 South.
Yes,
Okay. And then going on to 2013, January to May. Again, he lived with you at 10127 Highway 16 South.
yes,
And then finally, in 2014 of August, he moved in with you.
yes.
When did he leave in 2014?
I think. I think it was towards the end of the month
What month?
of August.
So he just lived with you in August?
Yes, in August.
Um,
Yeah,
And he lived with you at 734 Apple Valley.
correct.
You're aware that your brother's a convicted sex offender, right?
Yes,
So you know that you have to register with the Texas Department, or rather with whatever local law enforcement agency, and he has to provide an address, right?
yes.
Would it surprise you to know that based on his DPS records, he's never listed those
Jack is
addresses?
bringing into evidence a record that hasn't been admitted. He's reading from a governmental record, I think.
All right. That reading from the record, that objection will be sustained.
I'm just asking Judge if she would be surprised to know that he's never put that as his address.
All right. The objection is sustained as to reading from the record, but you may ask whatever question you wish to ask.
Okay. Well, Judge, we would move to admit State's Exhibit number 3, which is a certified document that relates to Mari Morales.
If I see it.
Yep.
Did y'all give this to me this time?
Yep.
Thanks.
I know so.
Certified record. It's 09. It's all the time. So he's 14. Police department change the status. October. They don't really say where you change the status to. No objection to State's Exhibit number 3.
All right. State's Exhibit number 3 is admitted without objection.
Okay, I'll read from it now. Would it surprise you to know that he's never listed that as an address?
yes.
Okay,
He lived there just a few days, and he went to, I think it was Eagle Pass with Veronica.
so help me understand this. You just testified that for months at a time, he was living with you.
And he
Right.
went, yes,
And then now you're saying it's just days?
no, on that month of August. He
Okay.
didn't stay the whole month of August.
Your Honor, may I approach?
Yes.
I'll show you what's been admitted in State's Exhibit number 3. Starting from 2011 all the way to 2014. You would agree with me, your address is never listed there.
Yeah, I never had him on the lease or anything, or he never registered either. It was just, I don't know. He just never did.
Okay,
That's when I think he was on the run.
okay. He was on the run for 3 years,
No,
4 years?
I'm not too sure.
Okay. So it's your testimony that this certified record, when he's going in and saying, this is where I live, is incorrect.
No,
So what are you saying?
what address?
All of those addresses that are listed here that you just looked at, none of them are your addresses on either one of those that you just testified to,
Mm,
right?
I didn't see right. I don't know what, I mean, I couldn't see right.
Okay, I'll bring it to you again. So going from 2010 or 2011, 2011,
Mhm.
2012, 2013, 2014, 2014. None of those are the addresses that you just testified to the jury.
No.
No, right?
Mm-mm.
Okay. This case has been pending for some time, right?
Yes.
Did you ever go to law enforcement and tell them that? Hey, you got it wrong. He was actually living with me. He could have never done it.
No, I mean, I didn't know what to do. I mean, I'm busy. I have my own life and it's just, I just know when he was with me.
So you care enough to testify, but never care enough to actually tell police that your brother's innocent.
I didn't know what to do.
Okay. And you would agree with me, this is the first time you're providing this information to the state.
Yes.
You ever try to reach out to the DA's office, but hey, I have some information for you?
No, because I didn't understand what was really going on. I didn't get so much information. And I know he couldn't have done it.
Okay. So those two addresses that you listed, was anybody else residing with you?
No, or just me and my kids
You and your kids?
and my ex-husband.
Okay. So they could come in here and tell the jury the same thing?
Yes.
Okay. And as far as this period of time that these two addresses, were you leasing those locations?
Yes.
And was he on a lease at any of those locations?
No.
Do you have any photographs of I don't know, his stuff at the location or any receipts to show that moving or anything at that location?
I might have pictures, but I have to look for them.
Okay. But you don't have any of that here with you today.
No.
We just have your testimony that's inconsistent with the state's exhibit number 3, which is where he's telling police and DPS where he's living.
Yeah, I guess.
I'll pass the witness.
No further
Defense.
questions, Your Honor.
All right, is this witness excused or subject for recall?
She may be excused.
State?
Oh, she can be excused, Judge.
All right, the rule has been invoked. What that means is you can't discuss your testimony with anyone. The only persons you're allowed to speak to are attorneys for the state of defense. Do you understand?
Okay, yes.
All right, you may step down. And this is the only witness to be called out of order?
This is the only witness to be called out of order by the defense, Your Honor.
All right, thank you.
Can we approach, Judge?
Yes. Ladies and gentlemen, we're going to stop right here today. I'm being informed by both parties that the next witness is going to take a longer time than 5 o'clock. And I always try to have you all out of here by 4:30 so you can avoid rush hour traffic. And I know it has been raining, so I want people to make it to their destination safely. And also, I don't like to have a witness testify and then both sides don't get a chance to question that witness. As you can tell, here in the 187 District Court, sometimes it's cold, sometimes it's hot. Usually, it's extremely hot. But I always say bring layers because it's easier to take off a jacket than need one and not have it. I know the chairs are hard. If you would like to bring a cushion, you're more than welcome to do that. Otherwise, we do have a few cushions in the back, but not for 14 people. The other thing, if you would like to bring anything to drink in the courtroom, you're more than welcome to do that. Just make sure there's a top on it because we try not to have things spill. We're going to start tomorrow with testimony at 9:30. If everybody is not here by 9:30, we cannot start at 9:30. Does everyone understand? All right. You've heard some testimony in this case. You're not allowed to discuss it amongst yourself. You're not allowed to start deliberating in your head. I will let you know when it's time to deliberate. If you hear anything about this case, you are to ignore it. The Deputy Mejia, he's going to give you some badges to wear. So that way, when you're in the courthouse or around the courtroom, or when I give you breaks, those badges need to be visibly displayed so people won't be discussing maybe this case or other cases around you. Does everyone understand? You're not to do any research on this case or try to Google or do anything of that nature. Everything that you need to know about this case will come from inside this courtroom. Does everyone understand? All right, so I will see you all here at 9:30 tomorrow. And there is a refrigerator in the jury room where the deputy is going to take you. So if you want to bring something, you can bring it and use the refrigerator. When you come and report tomorrow at 9:30, you do not come in the courtroom. Deputy Mejia will show you where you will report. All right, any questions? All right, yes. Oh, anything that has been admitted into evidence, you will have access to that. All right. All right, everyone, please rise for the jurors.